All right, let's just remind you about our question of the day. It's been a busy week rather, at the State Capture Commission of Inquiry. We heard from the person that is currently on the stand at the State Capture on a Saturday, former SAA Technical Board Chair Yakhe Kwinana. She's returned to the inquiry. But we wanted to ask you, what do you make of this week's SAA-related testimony? You heard from the former board chair, Dumieni, as well, with regards to using the privilege of not incriminating herself. That was the common refrain for most of the 3 days that she was on. So we will play you a clip a little later on with regards to the Deputy Chief Justice explaining the use of this privilege at the Commission. So stand by for that. But we want to take your thoughts with regards to this. What do you reckon with regards to this past week of testimony at the Capture, at the agenda_SABC? We have a few. Let's put it up, see what you have to say in this regard. Well, Lekasa says, she doesn't go straight to the answer. Yes, simple yes or no. South Africa should avoid catered deployment, says Lekasa. Skhwate says, Tobela Warablain, the viewers and listeners, it seems like we're getting somewhere, even though some of the questions are not answered. And those are the answers we want to know as a nation. We appreciate your comments up right there. All right, at the agenda_SABC is where we're at. We'll look at more of your comments in a short while. Watching a number of stories this morning. U.S. politics, U.S. elections, one of them. Stand by for any latest results. We'll bring that to you. Let's go now live to the State Capture Commission. Former SAA Technical Board Chair Yakhe Kwinana giving testimony at the Capture.
Actually, at a meeting, demanded that it be signed and that arrangements be made to go and retrieve it. And he said that you had said at a point in that meeting that people were not to leave the room until the agreement was signed. I understand your evidence previously to be that you deny that you were ever at that meeting, correct?
Chair, I was saying, after the award of this contract, there was a lot of unhappiness from the people who were not part of this process at all. I received a letter of complaint from the chairperson of the board. I received a letter from National Treasurer as the chairperson, and then there was also the media, and rightly so, because this is a big contract.
I'm going to interrupt you, Ms. Kwinana. Remember, the question was whether you confirm that your position is that you were not at that meeting that Mr. Phiri talked about. That was the question.
I'm trying to answer it, Chair.
Mm-hmm.
I'm saying...
Try and go straight to it as much as possible, because your answer may be, no, I didn't say I was not at that meeting, or yes, my position is that I was not at that meeting.
Okay.
I just want us to make progress.
I was at a meeting where I sat with management to say there is this concern. Please put together all the files, put together the contract, take everything to National Treasurer. Yes, I was in that meeting where basically we were addressing this unhappiness.
Okay. Ms. Hofmeyer.
Thank you, but you deny having at that meeting demanded that no one leave the room until the agreement was signed. Is that correct?
Definitely.
And you didn't ask for it to go and be retrieved. Is that correct?
No, Chair.
And Mr. Phiri also said that before he signed...
I'm sorry. She asks, is it correct? You say no. Is it no? It is not correct. No, it is correct. I just want to... I want to make sure we all understand your answer in the same way.
Chair, I was at a meeting which was addressing the specific issues. Yes. So
Of unhappiness. I think, Ms. Hoffman, you might have to repeat your question so
Yes.
that, and then when you answer, I just want to make sure when you say yes or no, that my understanding is what you intend to convey.
I think it'll be helpful if I change the framing of the question.
Yes, okay.
Ms. Kwinana, at that meeting, did you demand that no one leave the room before the agreement was signed?
I did not demand, because my understanding was that the agreement was signed.
Did you at any point prior to that meeting push for it to be urgently concluded, the drafting process?
No, Chair.
Who is Ms. Cookie Constance Mbeki?
She is the head of legal.
Where?
Then she was the head of legal at SAAT.
Right. Do you remember having an interaction with her during the drafting process for this contract?
No.
Because she has previously given an affidavit to the Commission. It was dealt with in Ms. Mamela's evidence. I can take you there so you can read it yourself, or I could just read you it. Would you like to see it in front of you?
Yes, Chair.
Certainly. We will need, Chair and Ms. Mbanjwa, DD 25B. And you'll open it, the first page of the affidavit is page 464. Yes, and page 464 is where it commences. B, 464. No, I've just, it should be in 25B, page 464. 464. Yes. Oh, some pages fell out. Thank you. Ms. Kwinana, do you recall having any interactions with Ms. Mbeki about the drafting? Because I understood your evidence previously to be once the board makes the decision, you leave it to management to execute it. Is that right?
Yes, Chair.
So, am I understanding correctly? Then you wouldn't have been following up with the drafting team or anything like that. Is that right?
Yes, Chair.
And is your evidence that after the board gave that, made that resolution on the 9th of May, you didn't thereafter become involved or follow up about the drafting at all?
No, Chair.
No. And you've already told us you dispute Mr. Piri's version about that meeting, so I'm leaving that. Now, what Ms. Mbeki, who was one of the people involved in drafting the contract, has said in her affidavit here, and we can pick it up at page 473. Paragraph 25. And if you go to page 25, paragraph 25, she's been dealing with various processes in the drafting, and about 2/3 of the way down on paragraph 25, she says that she'd had a conversation with Ms. Mamela, Advocate Mamela, and she says there's a sentence sort of 2/3 of the way down, during the telephone discussion. Can you see that, Ms. Kwinana?
Yes.
It says, during the telephone discussion, Advocate Mamela told me that she received a complaint that I keep on raising issues which were already discussed before I joined the team the previous day. And as a result of my conduct, the discussions were taking longer than necessary. She also told me that this concern was also raised with the then Chief Executive Officer of SART, who was also the Acting Group Chief Executive Officer, Mr. Musa Zwane. I admitted that indeed I'd been alerted by the team that a lot of the issues I was raising were already raised, discussed and resolved the previous day. And then she goes on at 26 to say, on the same day that Advocate Mamela told me about the concern from the contract negotiation team, I had a telephone discussion with Mr. Zwane, who informed me that he was in a meeting with the then Chairperson of SART board, Ms. Yakhe Kwinana, and that I am on speakerphone. He told me that I'm informed that the contract negotiation process, that I'm slowing down the contract negotiation process by raising issues which had already been dealt with, and that he was requested to intervene. Do you recall this conversation, that you were placed on speakerphone?
No, Chair.
Do you deny that it took place?
I don't remember it, Chair.
So it's possible it could have.
Not with contract negotiation.
You would not have been involved?
Yes.
So your answer is you weren't involved in this conversation?
I wasn't involved.
Because if it was just you and Mr. Zwane, and he said that he had been requested to intervene, do you agree it's a fair assumption that that request would likely have come to you, from you?
No, definitely it did not come from me.
And she goes on and she says, he told me that the purpose of his call was to ascertain what was going on and that he wanted to hear my side of the story. He gave an opportunity for me to explain my frustrations, and then she goes on and talks in some detail about the issues, etc. What I'm interested in is this reads, Ms. Kwinana, as yet another member of the SART team, now on the legal side, saying that you were involved in following up about the drafting of this contract. Is she giving false evidence by placing this version before the Commission?
She is, Chair.
And Mr. Piri is also, correct?
Mr. Piri is also. And in fact, Chair, maybe I should have been given Rule 3.3 here so that I can answer adequately.
You were alerted to the fact that it would be part of what was referred to today because it comprises part of Ms. Mamela's bundle. But you've given your answer. Is there anything you feel that you haven't been able to say?
No, Chair, but I am angry that knowing the processes, how would I go and say how far is the contract? The board is not involved there. In fact, that is what I have been explaining. The board is not involved in the documentation of the contract.
Ms. Kwinana, let me, in fairness to you, say I absolutely accept that. When processes are running correctly, the board should never be involved in that. It may on occasion, and I think this is a point that the Chair raised previously, if it's really important that something be in a contract when the board approves it, it may be appropriate from a corporate governance and a procurement perspective that the board checks again that it's there. But actually being involved in driving the process, in rushing it along, is something that board members should never do. Are we agreed on that?
Agreed.
Yes. What we're probing today is why many people at SART, many might be exaggerating, at least 2 people at SART, say you were playing a role in this contract which is contrary to the proper role of a board member, and we're exploring it today because the theme that is emerging from all these bits of evidence is that you played a role that is not an appropriate role for a board member to play, and if you received any benefits out of this contract, it would indicate that you were pushing for these bidders to be favoured and the contract to be signed so that they could be secured their revenue stream. And that's why I must, in fairness, put these to you. Just wanted you to be clear about why I'm going there. Chair, I then propose to move from this aspect.
1 second, Ms.
Oh, sorry.
Ms. Mbandra.
Chair, thank you. Chair, I decided to raise this concern after the witness has answered because I take cognizance of your warning to me the other day to say I must not be seen to be assisting the witness. What I now have, Chair, is a concern with the manner of questioning by Ms. Hofmeyer, specifically on this question. I won't be long so that I can take it to re-examination. I just want to state my concern so that in future, what Ms. Hofmeyer does, she reads a statement that does not say that the witness was there. And the statement clearly does not say that she was there. It is hearsay. Somebody is saying, I'm with Mr. X. And secondly, when that person speaks, that person does not speak in the plural, speaks in the singular, which means that I don't mind Ms. Hofmeyer putting the questions to the witness, but I object to Ms. Hofmeyer making the statement to be what the statement is not, because this is what is causing difficulty with this witness to answer. So if she can in future just be careful of that. If the statement does not say, I as Yakhe Kwinana am saying this, somebody says there was a hearsay to that, and then she is bombarded and conclusions are made, that becomes unfair cross-examination.
Well, just do you want to draw my attention to the specific part that you are talking about?
Thank you, Chair. If I can use, for instance, this paragraph that we are at now. It is DD 25, page 473.
47?
Yes, it is this.
474.
47. No, it starts at 473.
Yeah.
And then, reading from paragraph 26, it says, I had a telephone discussion with Mr. Zwane, who informed me that he was in a meeting with the then chairperson of SAT. It goes over to page 474. Who informed me that he was in a meeting with the chairperson of SAT. This person did not see Ms. Kwinana there. She says somebody phones me and say, I am in a meeting with the chairperson of SAT. That is Yakhe Kwinana. He informed me that he was informed. And then it continues, it says, he told me that the purpose of his call, without arguing, Chair, I know this is not the time. We can see that Mr. Zwane here is speaking in the singular. He doesn't say that, this lady doesn't say, he told me that the reason for their call. So even on Mr. Zwane's ipse dixit to this question, the witness was not part of that conversation. That is clear from this affidavit. And now here is where my concern is. My concern is what now Ms. Hofmeyer does is to say that this statement, which clearly does not say the witness said anything, is confirmation of the fact that the witness, I don't mind if she makes it like that, but what worries me is when she pushes it and presses it and makes it a fact. If we can just get us.
Ms. Hofmeyer?
Chair, I was quite careful to be very faithful to Ms. Mbeki's words, and it was in response to her very words that I asked Ms. Kwinana for her version. And all that I did thereafter was to explain to Ms. Kwinana that, in essence, answers about the way boards usually operate is not where we're going here. I wanted to establish with Ms. Kwinana that we are on common ground with that. What's being explored is the extent to which there is evidence from others that suggest a greater involvement. And in fairness to Ms. Kwinana, I must put what Ms. Mbeki said in her own words. If Ms. Kwinana would like to give the answer that Ms. Mbanjwa has just given, which is, well, look, you can't even rely on this because it's Mr. Zwane saying that I was in a room that I was not in, she's fully entitled to give that answer. What is difficult is, again, with respect to my learned friend, a situation where the type of answer that it might have been useful for Ms. Kwinana to give is then brought in through what is essentially argument or re-examination.
Yes.
So my request, Chair, would be that we do reserve it for that purpose. We are going to have a re-examination session today. My suggestion is these proceedings are going to move much more efficiently if we do that.
Okay, let's move on.
Right, so Ms. Kwinana, I'd like to leave the decision that the board took and your involvement thereafter in awarding the contract to JM and AAR, and I want to go back to actually where we left off on Tuesday, which is these monies that you received from JM Aviation, its bank account, into Zanospark's bank account, Ms. Hendricks, who directly deposited money, and the evidence that you've given the Commission on that score. Now, Ms. Kwinana, I must say, after Tuesday's evidence, it became clear to me, certainly, and please tell me if you disagree, that you really are, I think probably from about the time you left SART, you've been running quite a serious Forex trading business. Is that a fair summary of what you've been doing?
Yes, Chair.
And you did indicate in your evidence that you have ensured in conducting that business that you are FICA compliant. That's compliant with the Financial Intelligence Centre Act, correct?
Sorry, can you repeat the question?
Yes. I understood your evidence the other day to be that you have ensured that you are, as a business, FICA compliant. Is that correct?
I said the business is FICA compliant, but I do not need to have a license to do Forex trading.
Yes, no, I understand that difference. You dispute the evidence from the FSCA. We looked at their affidavit. You said, notwithstanding what they say about the licenses needed, I don't need that license. You and I agree on that. What I understand you to say, though, is you do accept that you are an accountable institution under FICA, and so you must be FICA compliant, correct?
No, Chair. I'm not an accountable institution under FICA. The accountable institution, let me get it for you in my red file, which institutions are accountable in terms of FICA.
Sorry, could I just ask, why would you need to be FICA compliant if you weren't an accountable institution under FICA?
No, FICA that I'm talking about is the normal FICA that everybody must comply with. Like, for instance, the copy of the ID and the proof of address. But let me read to you the companies that must comply with FICA as the financial institutions. It's the insurance companies. Zanospark is not an insurance company. Hedge fund managers, retirement fund managers, credit ratings companies, capital market companies, Forex brokers. We are not the Forex brokers. We are Forex traders. And therefore, we do not have to comply with FSCA requirements.
This is the Financial Intelligence Centre Act, right?
Yes.
So you're not a Forex broker, you're a Forex trader.
Yes, and in fact, even the Forex brokers, it's not a mandatory requirement that they must comply, because there are Forex brokers that do not comply, and it's not a requirement, but it is advisable that they can comply.
I'm going to come back to FICA in a moment. Just tell me, but you said you do have an obligation to get IDs and other things. Where does that obligation come from?
From our own requirements, because we need to put everything in place.
But then why do you call it FICA documents or FICA compliance?
Maybe it's the loose term. Like for instance, when you go to the bank, they say they want to FICA you, they want proof of address, they want the ID. So
yes, because they need to be. They are accountable institutions under FICA, right? So yes. I understand your evidence to be you're not an accountable institution under FICA, but you just engage in good practice. Exactly. Is that right?
Yes.
Right, okay. Under FICA, sorry, let me move on from that. I'll come back to the FICA aspect in a moment. On Tuesday, you did say, though, and I think it's part of your good business practice, that you know your client documents from your clients. Yes. Like if you were obliged to do so under FICA, you would have been obliged to get, correct?
Yes.
Yes. And those documents you have not provided to the Commission, correct?
No.
No. And were those, is that because they were on that server that was confiscated?
Yes, sir.
Yes, okay. Now, that server, as I understood your evidence earlier, was confiscated for non-payment in February 2020. Is that correct?
Yes, sir.
Yes. And similarly, the annual investment statements that you say that you prepare, you don't ever email because of confidentiality concerns. You print them out and then you go and hand deliver them. Is that correct?
Yes, sir.
And you also indicated that you deliver them in January of every year, correct?
Yes, sir.
And those documents you also couldn't provide to the Commission because, despite the summons that you received, because of the confiscated server. Have I got the evidence the other day correct?
Yes, sir.
You did say, however, in your evidence that you weren't certain that the confiscation happened in February 2020. Is that right?
Yes, sir. I even said the date may be wrong.
Yes.
But the confiscation is correct.
It did take place, indeed. So, if we had been in contact with Onero, who you said was your service provider, and they indicated that the confiscation actually occurred in April of 2019, would you dispute that?
No, sir.
Okay. So, right, let's move on from that for a moment. On Tuesday, in your evidence, we looked at the JM agreement that Ms. Sokulu sent to Ms. Mamela. Do you remember that, when the bid was still open and she was asking for Ms. Mamela's input on it? Do you recall that?
Yes, sir.
And in terms of that JV agreement, you would have seen in the email, JM Aviation was going to earn 5% on all the invoices generated by AAR. Were you aware of that at the time, that these decisions were being taken?
No, Chair.
I just want to get a sense of how much value this contract was for JM Aviation. And I know that you're an accountant, which I am not, so you might be able to assist me. I did, the value of the components contract, we've received evidence previously in the Commission, is about, over the 5 years, 1.5 billion. Does that accord with your understanding?
Yes, Chair.
Now, 5% of 1.5 billion, on my calculation, is 75 million. Does that sound right to you?
Yeah, maybe.
Yeah, we could do the I did do it, but sometimes when I've had accountants here, they can do it in their heads, so I'm always just a little bit cautious. So 5% of the total value of that contract, if I've done my calculation correctly, is about 75 million rands worth of business for JM Aviation. Do you accept that calculation?
Let me get my calculator, Chair.
You can't trust these lawyers, Ms. Kwinana.
No, you certainly shouldn't. Not on matters of
figures.
numbers.
And I can't blame you.
Sorry,
So
Chair,
how much
I'm not
is it?
interrupting.
Yes.
I would just like to be given the page, if Ms. Hofmeyer can kindly give me the page where there is
Page.
5% of...
I'm going to have to just remember where it is. It's in that email, so it'll be in the Mamela bundle. It's the... I'll be able to find a quicker reference. Sorry, let me do that.
So I'm calculating
5%.
1.253. 1.253.
5% of 1.5 billion, I think. Is that correct, Ms. Hofmeyer?
Yes.
5% of 1.5 billion.
But this is 1.253. 636,151.
Sorry, 5% of 1.5 billion is what?
Where is 1.5, Chair?
No,
Okay,
the value of the contract over the 5 years is 1.5 billion. So I just want a calculation of what 5% of 1.5 billion is.
The value of the contract, Chair, according to DD 22, page 2282, is 1.253.
Well, 5% of 100 million is 5 million.
No, sorry, I understand where Ms. Kwinana and I are at odds. You're absolutely right. On that page, when the submission was made to the board, it was valued at about 1.25 billion, right? The evidence of Mr. Human, who appeared before the commission, who at the time was employed at SART, was that there had been overruns on the contract and that it was in the end going to be 1.5 billion. So that's why I give you that figure. Oh, we're on the same page. So can you just do me a calculation of 5% of 1.5 billion?
I think you were right about 75 million.
I think so too,
Yeah,
but I want
think
to
you
give
are
the
right.
witness an opportunity.
I'm not an accountant, but
No.
I think you're right because 5% of 1 billion would be 50 million, I think.
That's 75 million.
Yes. Okay,
Yeah.
so we're agreed on that.
So lawyers aren't so bad with figures, Ms. Hofmeyer.
Yes, sorry, Ms. Mbanjwa had the request. I can give it to you, Ms. Mbanjwa. The reference is DD 18, page 339.
Maybe we can also be assisted with one other thing, Chair, because for us it will help with re-examination as well. According to also what Mrs. Kwinana raised is also what I saw, because I thought that the value of the contract was supposed to be in the submission, in that board submission. Now, is it Ms. Hofmeyer's conclusion that actually that value that was in the board submission was an incorrect value?
No. Ms. Mbanjwa, it's the evidence of Mr. Human. He said, he's not saying that's wrong. He said, as the contract has developed over time, it has become more costly. So in the end, because it was running currently, I understand it's now been cancelled, but it was running currently, and so what it was going to end up costing SART was about 1.5 billion. That's why I'm using that, because if that's what it did end up costing SART, then JM Aviation had a look through to 5%, and that's about 75 million.
You know, so I really don't want to hold up. I hear this evidence of Mr. Human, but can we be referred to something that proves that at the end this was the value?
Chair, this is really not...
Yes, she's saying Mr. Human's evidence. Mr. Human came and gave evidence, and that's what he said. Obviously, if you want to calculate 5% of the amount that is reflected there, you are free to do so.
Thank you. No, I think I've held you up enough, so thank you. We may continue.
Okay, all right.
Thank you.
Let's move on. Thank you, Ms. Kwinana, for confirming that the lawyer was right about figures.
Okay, so out of the AAR JM Aviation contract, JM Aviation stood to receive revenue of about 75 million. If Mr. Human is right, that its ultimate value is 1.5, if it's a bit less, 1.2, we can do the calculation. And it'll be some tens of millions less than 75 million. Do you accept that as well, Ms. Kwinana?
Yes, Chair.
Yes. And then they also benefited from the sale of the GPUs to them, and then their ability to on-sell it to Swissport. Is that correct?
Sorry, what's your question?
That JM Aviation also benefited from the fact that SART sold its GPUs, which it was then able to sell on to Swissport, correct?
I can't confirm this one.
Do you not have knowledge of that?
I don't know if they unsold and benefited.
Oh, okay. Let me help you again. The evidence is that SART sold it to JM Aviation at about 3 million, it was 3.3 or something, and the next day Swissport paid for those same 12 GPUs at about 9.8. So I've always worked with the difference being about 6 million rand. Do you accept that if JM Aviation bought them for about 3 million and the next day they could sell them for 9 million, they benefited by the difference, which I'm going to say is about 6 million. Do you accept that?
There was also a board submission in respect of this.
Yes, my question is, do you accept that if they bought them for 3 million and sold them for 9 million the next day, they made 6 million out of that transaction?
There was a board resolution in respect of this, Chair. And in this board resolution, there were some also questions that were raised.
Yes, but hang on, Ms. Kwinana. She's just asking you whether you accept that reasoning. She's saying, if you buy something for 3 million today and you sell it for 9 million rand tomorrow, do you accept that it means you have made a 6 million rand profit?
Not necessarily, Chair.
Okay, all right. Ms. Hofmeyer?
Why not?
It's because if I make an example of a car, you sell a car, you buy a car today, Chair, for 200,000. It gets registered today and you sell it tomorrow. You sell it tomorrow, you can sell it tomorrow at 150 because of the depreciation.
Indeed, indeed. But the facts are, they bought it on day one for 3 million and they didn't sell it at a depreciated value, they sold it the next day at 9 million. How could they possibly not have benefited in the order of 6 million? There's no depreciation issue. Buy on day one at 3 million, sell on day two at 9 million.
Still, Chair, it also depends on the whole lot of things. I'm talking about the depreciation. We all know that the car depreciates it the moment it gets out of the showroom. It has already depreciated.
Yes, but you see, you are responding to a general principle. You are saying, in effect, that's not always the case. There are circumstances where you might have to sell something for lower than the amount you bought it the previous day.
Yes,
you make the example of a car. But what she's talking about is where it is a fact that they sold it for more than the price they paid for it. So your example doesn't apply. They bought this for 3 million. Today, tomorrow, the following day, they were able to sell it for 9 million. How can it not be that they made a profit of 6 million rand? How can you not agree with that?
Again, Chair, in the example of the car,
Yes,
can
but leave out the example of a car. Talk about what she's talking about.
talk about the GPUs.
Talk about any purchase.
Then
Day
let me
one,
talk
3
about-
million, tomorrow sell for 9 million.
Then let me talk about the purchase of a car, Chair. Let me make an example of the purchase of a car.
But,
No, but the
your own evidence says, in the case of a car, you won't sell the car for a higher price than the one you bought it for. That's your own evidence.
Yes, Chair.
But she's saying to you, if you buy anything today and you are able to, for 3 million rand, and you are able to sell it for 9 million rand tomorrow, obviously you have made 6 million rand profit.
If you haven't made any improvements, Chair.
Yes, if you have not
haven't-
incurred any expenses,
If
or-
you haven't incurred any other expenses,
then you agree.
the answer is yes.
Okay.
Thank you.
All right, 1 second, Ms. Mbanjwa.
Thank you, Chair. I just want to remind Chair specifically. You will recall, Chair, that this was the same question that was placed in front of Ms. Memela. And then what we had said then, we had said that the determination of the
Chair,
price-
I'm so sorry, Ms. Mbanjwa.
Yeah.
I really do want to place on record now that we will argue in due course, and that is the only reason I'm interrupting Ms. Mbanjwa, because I have to interrupt to tell you that if at this point you have interjected in a way that is going to be viewed as coaching this witness, we are going to make that submission in due course. I need to tell you that that is what I'm going to do in fairness to you, but please proceed if you'd like to carry on.
But as I've been saying also, Ms. Mbanjwa, I'm very concerned about that.
Yes,
and
but
it's not
but
doing-
it's not that.
It's not doing justice to Ms. Kwinana, who I believe can mostly answer questions on her own.
Yes, but Chair, you are going to listen to what I'm going to say, and you will see that it has nothing to do with the answer of Ms. Kwinana.
Yeah.
And actually, Chair, maybe this may appear a joke. I'm not making light of this. She is actually Mrs. Kwinana. There is somebody who tweeted, "Oh, Mrs. Kwinana, no wonder they are not even married, they are gangsters." So maybe we should emphasize that she is Mrs. She has been married for more than 20 years. Thank you, Chair. But Chair, what I wanted to say is this, with your permission. When Ms. Memela was giving evidence the last time, we requested a specific affidavit, the affidavit of Jules S. And Jules S. was at Swissport. One of the things, and that affidavit, we confirmed with Ms. Hofmeyer that she is in possession of that affidavit. That affidavit expressly stated, and we drew the attention of Ms. Hofmeyer to that, it expressly stated that the GPUs that were sold, some of them were broken, and they were taken for repairs, which means costs were incurred. I was just reminding the Commission that the issue of whether it was 6 million the profit is fully set out in that affidavit. Thank you, Chair.
Ms. Hofmeyer, please
Thank
move
you.
on.